Hello friends, welcome to Law and GK. So friends, on this channel we discuss the contents of law and previous year papers of judicial services and other legal exams. And friends, we have already started our series for Jharkhand Judicial Services. See, the Jharkhand Public Service Commission has notified two advertisements, 110 and 111 of 2015. The 11 of 2015, that 2015B, we have already discussed, and today we are discussing the 2015R, the 10th advertisement of 2015 of Jharkhand Public Service Commission, which was held in May 2016. I hope कि ये वीडियोस आपके लिए बड़ी यूजफुल रहेंगी. So friends, if you are preparing for judicial services, this channel will be very useful for you. आपके लिए बड़ा ही बेनिफिशियल रहेगा. एंड अगर आपको ये वीडियो अच्छी लगी हो तो जरूर लाइक कीजिएगा, शेयर कीजिएगा अपने फ्रेंड्स के साथ. And don't forget to subscribe the channel. And while subscribing, don't forget to press the bell icon so that you can get the notification of our upcoming videos. And अगर आपको हमारे efforts अच्छे लगे हो तो in addition to like and subscribe, kindly give us a super thanks. Super thanks is a way to appreciate the content creator. आप जो है जो भी कंटेंट बनाता है उसको अप्रिशिएट करने के लिए आप जितना भी अमाउंट चाहें डोनेट कर सकते हैं. मिनिमम इज 40 रुपीज. सो डोंट फॉरगेट टू गिव अस अ सुपर थैंक्स. सो लेट्स मूव टू द क्वेश्चन पेपर. So the paper comes like this. It is series A and this is preliminary test 2015R. This was the Advrt 10/2015 and the exam held on 25th June 2016. You have to fill your roll number here. Black and blue ballpoint pen can be used. 100 questions, 1 mark each and no negative marking. So question number 1 to 10 is English always. Question number 1 is which of the underlined part of the given sentence contains an error? One of my sister lives near India Gate in New Delhi. So see, there is no error in this question. The examiner has made a mistake in the question. How one of my sister, it should have been sisters, so that mistake should be here. It should be sister, not sisters, but it is already one of my sister, so it is already correct. So there is no mistake in this question. However, an answer key has given the answer A. Why? Because they have missed this S over here. The incorrect sentence was one of my sisters lives in near the, so the error was in sisters. एग्जामिनर ने यहाँ थोड़ी गड़बड़ कर दी. वो यहाँ पर सिस्टर्स लिखने चाह रहे थे बट लेकिन उन्होंने एस यहाँ पर मिस कर दिया और इसकी वजह से ये जो क्वेश्चन जो है वो वैसे ही ठीक हो गया. तो जो एरर निकालते हैं तो क्वेश्चंस आते हैं जैसे इसमें तो वन ऑफ माय सिस्टर्स लिखा होता है तो उसमें एरर ए में आ जाता है कि भाई ए में एरर है, वन ऑफ माय सिस्टर होना चाहिए. तो इसलिए यहाँ पर जो है ये नो एरर है. और वैसे आंसर की जो दी गई है वो ए दी गई थी, इसलिए दी गई थी कि उन्होंने सोचा कि वो सिस्टर्स है, बट यहाँ पर एस जो है ऑलरेडी नहीं है तो इसमें कोई एरर नहीं है. Next question number 2. Fill in the blank with a suitable form of verb in the following. My friend is living in Mumbai या फिर has been living in Mumbai. Now see there is since here. So this is present perfect tense. So my friend has been living in Mumbai since 2014. So B is the answer. Next 3. Fill in the blanks with an appropriate preposition. They belong to same party but they do not agree in everything, at everything, on everything. On everything. C is the answer. Next is 4. The word millennium refers to a period of 1,000 years. C is the answer. Next is 5. Fill in the blank with the suitable choice. Delhi is hotter than Shimla or hotter than Shimla? Hotter. B is the answer. Next 6. Which of the following is similar meaning of that which cannot be read? It is illegible. C is the answer. In the previous paper 2015B we have discussed this thing over there because it was asked that what is the nearest meaning to illegitimate. The answer was illegal and illegible and illogical was also in options. And at that time I also mentioned this. Eligible means which cannot be read. C is the answer. This is 7. Select the appropriate choice to fill in the blank in the sentence. Dash tigers are ferocious. A tiger, no, it is as, and there is no No, no. So no article is required. Tigers are ferocious. This sentence is correct. D is the answer. Identify the type of sentence given below. Can you lend me your pen? Please. So this is an declarative, operative, or imperative. No, it is interrogative. D is the answer. Can you? And there is question mark. So it is interrogative. Next is 9. An ophthalmologist treats the disorder of eyes. C is the answer. The same type of question is coming every year. So we discussed this in 2018 and 2016 as well, है ना? Who treats disorder of skin? Dermatologist. Heart? Cardiologist. है ना? Brain? Neurologist. Next 10. The word terrestrial means connected with land. B is the answer. Next is 11. Who appoints the judges of High Court of India? President of India. C is the answer. Next 12. The year of Quit India movement is 1942. C is the answer. Next 13. Deficiency of which of the following vitamins cause night blindness? It is vitamin A. B is the answer. I have made a video on vitamins and also on blood group. I will mention the link of the videos in the description box, so you just go over there and look at the vitamins. For example, deficiency of vitamin C causes scurvy, है ना? D, rickets, है ना? So you can just go over there and look at the deficiencies on vitamins and blood groups as well. It is helpful for you. Next is 14. One of the following gases is the cause of greenhouse effect, warming of Earth's surface. That is carbon dioxide. C is the answer. Next 15. The UNO was formed on 24th October 1945. A is the answer. Next 16. The American Journal Time has chosen one of the following as the person of the year 2015. At that time it was Angela Merkel. And who was chosen as Times the person of the year for 2022? That Ukrainian President Vladimir Zelensky. Next 17. Amravati is being made new capital of which of the following state? Andhra Pradesh. B is the answer. Next 18. Justice Meenakshi Madan Rai has been sworn as the first woman judge of High Court of which of the following states? It was Sikkim at that time. So A was the answer. Next is 19. Who of the following is the writer of the book Wings of Fire? APJ Abdul Kalam. B is the answer. Cristiano Ronaldo has recently been voted as #1 footballer. He hails from which of the following countries? He is from Portugal. C is the answer. So they are asking from the current affairs. Keep preparing for the current affairs. Next 21. A magistrate has the power to direct the police to investigate into an offence in CRPC. That is 156(3) CRPC. A is the answer. Next 22. Under the scheme of Criminal Procedure Code, non-cognizable offence are private wrongs. A is the answer. And non-cognizable offence is defined where? In section 2L of CRPC. Next 23. Under section 159 CRPC, the magistrate has the power to depute any magistrate subordinate to him to hold a preliminary inquiry or direct investigation by the police. You can do either. C is the answer. Next 24. Under section 167 CRPC, the nature of custody can be altered from judicial to police custody and vice versa. This alteration can be done during the first 7 days or first 15, 14, 10. First 15 days. B is the answer. Next 25. Cognizance of offence of defamation under chapter 21 IPC can be taken on a complaint made by an agreed person, on a police report or suo motu. On a complaint made by an agreed person. A is the answer because it is a non-cognizable case and a complaint case. And this is mentioned in section 199 CRPC. Next 26. Joint trial of several persons is permissible under section 223 CRPC. D is the answer. Next 27. Rule entry for acquit or entry for commit. See, they have made a mistake here. This is autrophoes. Acquit and autrophoes. Convict. As I mentioned earlier, there are several spelling mistakes in the paper. So it is contained in section 300. B is the answer. Next 28. In which of the following cases the Supreme Court held that High Court cannot directly entertain bail application of Pota accused without its refusal by a special court? It is State of Gujarat versus Salim Bhai Abdul Ghaffar Sheikh. B is the answer. It might have been in recent cases. Next 29. A legal remembrance cannot be made ex officio public prosecutor. It was held in case of. None of the case was from here, so answer was none of the above. D is the answer. See, there was a decision of Calcutta High Court in case of V.K. Godwani versus State and others. And this is remembrancer, not remembrances. Next 30. Urgent case of nuisance and apprehended danger falls under section 144 CRPC. B is the answer. Next 31. When warrant also cannot be executed, the court may proceed under the substituted proceedings in section 82 and 83 CRPC. B is the answer. Next 32. Plea bargaining, a new chapter was added in CRPC by Criminal Law Amendment of 2005 is contained in chapter is 21A and section is 265A to 265L. C is the answer. Next 33. A magistrate may under section 252 or section 255 CRPC convict the accused of any offence triable under chapter 20 of CRPC. B is the answer. Next 34. In which of the following cases the Supreme Court held that FIR was not substantive evidence and could only be used to corroborate its maker? It was held in C. Magesh versus State of Karnataka. D is the answer. This is a repeat question. Next 35. In summons case and inquiries, memorandum is the only record of witness, accused statement of evidence. Evidence. C is the answer. Next 36. If the accused is not acquitted under the section 232 CRPC, then the court calls upon him to enter on his defense. A is the answer. Next 37. In case of anticipatory breach of contract, an aggrieved party has a right to claim performance at any time or cannot claim any remedy if it may wait till the date of performance. Has right to claim performance at any time and also does have right to claim to terminate the contract, and it is mentioned here does not. So these three are incorrect. A is the answer. And where is the provision for anticipatory breach in Contract Act? It is in section 39. Next 38. Which of the following statement is not correct? Acceptance must be communicated. Yes, obviously. Must be in writing. It is not necessary. Oral acceptance is valid. Acceptance, yes. Must be in a prescribed manner. Yes, it is correct. What is not correct? B. B is the answer. Next 39. The principal restitution stops where repayment begins. Can be applied against an alien enemy of an incapable person, lunatic idiots, minors. Minors only. D is the answer. Next 40. Promissory estoppels is sometimes spoken of as substitute for consideration. B is the answer. Next 41. A change of nature of obligation of a contract is known as novation. D is the answer. If it is mentioned that a change in nature of obligation in a contract, then it would be alteration, because the changes is made in the contract and not the whole obligation has been changed. If the whole obligation has been changed, then it is novation. If the only part of obligation is changed, then it is only alteration. So you need to understand this. Next 42, a notice in the newspaper inviting tender is invitation to proposal. C is the answer. Next 43, examine the following statements. Every contract is an agreement. Yes. Every agreement is a contract. No. Every lawful civil obligation is a contract. No. Every contract has legally enforceable civil obligations. Yeah, it is correct. So 1 and 4 are correct. A is the answer. Next 44, Union of India versus Mandala Tathaiya is an illustration where tender was in form of standing offer. B is the answer. Next 45, the rule laid down in Adam versus Lindsell was approved by the House of Lords in Dunlop versus Higgins. A is the answer. What rule they applied? Postal rule. The main base of postal rule is this case Adam versus Lindsell. Next 46, which one of the following agreements is held to be opposed to public policy? The arbitration clause for application of foreign law? No, it is not. Payment in foreign currency? No. Agreement of payment less salary? No. Yes, it is against public policy. Arbitrator residing in foreign country? No. So C is the answer. Next is 47. The fact of Griffith versus Bremer would attract section 20 and facts of Krell versus Henry attracts section 56. Doctrine of frustration. Doctrine of impossibility. D is the answer. This is coronation case, na? Krell versus Henry. Next 48. The obligation to restore advantage in a void agreement is provided by Section 65 of Indian Contract Act. A is the answer. Next 49. A continuing guarantee under Section 130 is irrevocable absolutely या फिर revocable absolutely no. It is revocable as regard to future transactions. B is the answer. Next 50. For the purpose of pledge, delivery of possession of goods may be symbolic or actual. It has to be actual, not symbolic. D is the answer. Next 51. A valid lease can be determined by force majeure, frustration, afflux of time. Usually by afflux of time. C is the answer. But I would say this is a controversial question. Next 52. There can also be sale by estoppel if ownership of fraud possession. Sale by estoppels. A is the answer. Next 53. Causing of death of child in the mother's womb is not homicide as provided under explanation 3 to section 299. D is the answer. This is a repeat question. There are several questions which repeats every year. Either they just change the language of the question, but the answer is always same. The provision is always same. Next 54. Section 511 does not apply in the case of attempt to rights. Yes. Where the provision for rights in 146, theft 378, affray 159. Attempt to murder, there's a specific provision under section 307. So 511 is for attempt. So if there is specific provision for attempt to murder, then 511 will not be applied. So D is the answer. Next 55. Assault cannot be caused by mere gestures, words, preparation. Mere words. B is the answer. Next 56. Personating a public servant is an offence under section 170 IPC. C is the answer. Next 57. The Supreme Court of India has observed a clear distinction between dishonestly and fraudulently in case of Vimla Dev versus Delhi administration. D is the answer. Very common question and a repeated question. Next 58. The minimum duration of imprisonment provided for an offence under IPC is imprisonment for 24 hours. Yes, but what is 511? We just discussed this. It is for attempt. So it is in section 510. So B is the answer. Next 59. The principle underlying in section 95 of IPC is de minimis non curate lex. Repeated question. A is the answer. Non compos mentis is in section 84. Actus me in vitro factus known as mens actus. This is for section 94 IPC. Next 60. Section 97 IPC expressly states that right of private person is subject to restriction contained in section 99. A is the answer. Next 61. The language of part 3rd of section 105 is similar to that of. Now I would say this is a controversial question. So 105 of what? 105 in IPC is a commencement and continuation of right of private defense. And the answer key was given for 39. 39 is voluntarily. And 37 is cooperation by doing one act of several acts. 38 is person concerned in criminal act may be guilty of different offense. And 40 is definition of offense. So I did not find this question in proper way. Next 62. Which of the following section of IPC has incorporated the English law known as principle of second degree? That is section 114. A is the answer. It is about abatement. And abater is present when offense is committed. Next 63. The definition of criminal conspiracy in section 120A IPC has taken form that given in Quinn versus Latham. B is the answer. What is 120? Next 64. Homicide cannot be defined as killing of a person by a person in view of the nature of definition of the word person in. Now they are asking me the definition of person. Person in section 11 IPC. B is the answer. 13 is deleted. It was green. 9 is number. And 7 is sense of expression. Next 65. The requirement of possession has been highlighted by illustrations. In which illustrations of section 378? What is 378? Definition of theft. And which reflects the requirement of possession? C, D, E, F. C is the answer. Now see, this is a difficult question, I would say. So you need to just write in the Bayer Act. Just write down in your Bayer Act in front of C, D, E that it is illustration of requirement of possession. Next 66. Theft under IPC differ from larceny in English law, which contemplated permanent gain or loss. A is the answer. Next 67. A instigates B to murder C, who refuses to do so. A is guilty of abatement to commit murder. A is the answer. And this is illustration. A in section 108. Abatement. Next 68. Which one of the following brings out distinction between section 34 and 149? See, this is a repeat question, isn't that? Section 149 creates specific offense. 34 does not. It is correct. 34 creates specific offense. No, the two are contradictory. So if one is correct, so another is incorrect, obviously. 34 as well as 149 create specific offense. No, does not create. Do not create. No. So A is the answer. Next 69. The CPC Amendment Act of 2002 permits evidence in the form of affidavits. B is the answer. Next 70. It has been held by the Supreme Court in R.M. Malkhani versus State of Maharashtra that a contemporaneous tape record is relevant conversation. Is a relevant fact. It is gesti. B is the answer. Next 71. Section 11 of Indian Evidence Act enables a person charged with a crime to take what is commonly called the plea of alibi. And what is meaning of alibi? Elsewhere. I was somewhere else when the crime was committed. Plea of alibi, C is the answer. Next 72. A judicial admission operates as an admission. It is already an admission. Confession, no. Plea of ignorance, no. Waiver of proof. So when there is an admission, so there is no need for proof. D is the answer. Next 73. The burden of proof means the obligation to prove a fact. This is defined under Section 101 of Indian Evidence Act. B is the answer. Next 74. The principle stated in section 106 of the Indian Evidence Act is an application of the principle of res justa is where section 6 res judicata in 11 CPC. Rex 6 tantibus. This is a principle of international law. What it means? TT must be followed. So what remains? Res ipsa loquitur. B is the answer. Things speaks for itself. Next 75. Leading questions can always be asked in cross-examination. C is the answer. It is mentioned where? Section 143 of Evidence Act. Next 76. Alibi is governed by... Oh, come on. Earlier they have mentioned the section and asked where is alibi. Hai na? So now they are mentioning alibi here and asking the section. How easy it is to answer it. C is the answer. Section 11. 6, as I mentioned, it is res justae. 8 about PCM. What is PCM? Preparation, conduct and motive. Next 77. Admissions made by a party are evidence against previes in estate law blood. In estate. A is the answer. Means person having mutual interest. Next 78. Next 78. Communication made without prejudice are protected under Section 23 Evidence Act. C is the answer. Next 79. Necessity rule as to the admissibility of evidence is contained in Section 32. C is the answer. Next 80. The res inter alia acta is receivable under which section? Section 46 of Evidence Act. C is the answer. What is the meaning of res inter alia acta? Contract made by other people cannot affect the right of non-party. Next 81. Section 92 of Evidence Act applies to bilateral document or unilateral? Both. To bilateral documents. A is the answer. Next 82. Estoppel need not specifically pleaded या फिर should be specifically pleaded? It should be specifically pleaded. B is the answer. Next 83. Zahira Sheikh was prime witness in Best Bakery retrial case 2006. So A is the answer. Next 84. The presumption under section 41 of Evidence Act is irrebuttable presumption of law because it is conclusive proof. D is the answer. Next 85. Pecuniary jurisdiction of the court has been dealt with Section 6 of CPC. A is the answer. Next 86. Section 20 CPC does not apply to arbitration proceedings or civil proceedings. Obviously arbitration proceedings. A is the answer. This is a repeat question. Next 87. Under orders for Rule 1 of CPC, a suit is instituted when a plaint in duplicate is presented in the court. A plaint is presented या फिर in triplicate. In duplicate. A is the answer. Next 88. A suit in representative capacity can be filed by virtue of Order 1. Yes, but which rule? Rule 8. C is the answer. Next 89. List of witness after settlement of issue must be filed within 15 days. D is the answer. It is mentioned where? In Order 16. That is summons to witnesses in Rule 1. Next 90. Pleading can be altered or amended under Order 6. Which rule? Rule 17. D is the answer. This is a repeat question. Next 91. A suit can be dismissed in default under Order 9, Rule 3 and 8 as well. So both B and C is the answer. D is the answer. Next 92. An application under Order 9, Rule 7 CPC can be made. There is no time period is fixed, so at any time on or before the next date of hearing. C is the answer. Next 93. Judgment on admission can be given under Order 12, but which rule? Rule 6. C is the answer. Next 94. Judgment and decree have been dealt under Order 20. In the last paper that they asked for Order 21 execution. So A is the answer. What is Order 20A? It is costs. And Order 19 is affidavits. Next 95. Provisions relating to interpreter suit are contained in Order 36 CPC or 35 or 35 CPC. D is the answer. Order 32 is for suit by or against minor or person of unsound mind. 34 is suit relating to mortgages and 36 is special case. Next 96. Order 12 Rule 8 permits to notice to admit facts या फिर admit document. It is to notice to produce documents. C is the answer. Next 97. Under which section of CPC the principle of equity, justice and good conscience are prescribed? Section 151, that is inherent powers of the court. Next 98. Which of the following decision is not a decree within the meaning of section 2.2 of CPC? 2.2 is definition of decree. So dismissal of an application for final decree. It is a decree. Award of tribunal in land acquisition case. No, it is not. An order of abatement. It can be. Modifying a scheme under section 92. It can be. So award is not a decree. B is the answer. Next 99. Which of the following is a suit of civil nature? A suit for upholding mere dignity of honor. No, it is not. Suit for accounts. Yes. Expressly barred by some enactment. It is not. Suit relating to political questions. No. So B is the answer. Next is 100. The material fact on which a party relies are called as facta probenda. B is the answer. And on the basis of which facta probenda is proved, that is facta probentia. So friends, here we have discussed the preliminary exam paper of Jharkhand Judicial Services 2015 R, which was held on 25th June 2016. अगर आपको इसमें कोई कमी लगी हो, कोई सजेशन हो, कोई एडवाइस हो, कोई कमेंट्स हो, तो आप जो है कमेंट सेक्शन में जाकर भी लिख सकते हैं. वी ऑलवेज अप्रिशिएट योर कमेंट्स. एंड अगर आपको ये वीडियो अच्छी लगी और एफर्ट्स हमारे अच्छे लगे हो तो उसको जरूर लाइक कीजिएगा, शेयर कीजिएगा अपने फ्रेंड्स के साथ, सो दैट दे कैन कम टू नो अबाउट आवर चैनल एंड वो भी बेनिफिट ले सकें. एंड अगर आपको हमारे एफर्ट्स अच्छे लगे हो तो इन एडिशन टू लाइक एंड सब्सक्राइब काइंडली गिव अस अ सुपर थैंक्स. सुपर थैंक्स इज अ वे टू अप्रिशिएट द कंटेंट क्रिएटर. आप जो है जो भी कंटेंट बनाता है उसको अप्रिशिएट करने के लिए कोई भी अमाउंट जो है डोनेट कर सकते हैं. फ्रॉम मिनिमम स्टार्ट्स विद 40 रुपीज़. तो काइंडली गिव अस अ सुपर थैंक्स. So friends, thanks very much for watching this video. Thank you.